We often think of land as being just what we can see, rolling hills, trees and crops, or maybe roads over the surface. However, land rights can also extend underneath that surface, and that's where many legal aspects come into play.
In Michigan, if you own a piece of property, real estate, the first thing you should check is, do you own the mineral rights or not? Because in Michigan, like many other states, but not all states, the minerals can be separated from the surface. So you could have a situation where you own the surface, the real estate, but you don't own the minerals. Or you could have a situation where you own the surface and you own the minerals, or some part of the minerals.
David L. Porteous is an attorney with the McCurdy, Wotilla, and Porteous law firm. He says that knowing exactly which type of land rights a person has can be very important.
And the reason that that's so critical is because if you own the surface, but you don't own the minerals, whoever owns the mineral rights has the right to lease those mineral rights, and the oil company has the right to come on the land and drill for oil and gas, and the monies that are derived from that go to the mineral owner, not the surface owner. So you can see it becomes really important to know whether or not you will have the right to get revenues from an oil and gas well, or you could own the property and have an oil and gas well on your land and you don't get a dime from it.
In a situation where a person owns land but does not own the mineral rights, an oil and gas company could legally have claim to drill on that property.
Now let's look at the situation of you owning the surface but not the minerals. What that means is whoever owns the mineral rights can lease that, and the oil company would have the right to come on your land and drill for oil and gas. Now it doesn't mean that, let's say you have a small piece of land with a house and sort of a normal backyard, that you're going to have a drilling rig in your backyard. But if you own a 20-acre piece or a 40-acre piece or a larger piece, you absolutely could have the oil company someday approach you and say, we're going to be drilling a well. We're going to be offset from your barn or offset from your house a couple hundred feet, but you're going to have a rig out there for a month or a couple of months drilling for oil and gas, and it will have an impact on your land.
It's clearly important to know which specific rights a landowner has, and luckily it's not terribly complicated to figure out.
The ownership of mineral rights or the ownership of the surface rights are done by checking at the Register of Deeds office in the county where the property is located. And you can have a title search done, which is generally done by a title company or a lawyer who can look and determine whether or not you own the mineral rights or not.
If a person does own the mineral rights to the land, there are three major factors that should be carefully considered before any drilling agreement is signed.
And the typical things that you want to be thinking about if you're considering oil and gas leasing are the following. One is, how long will the lease be? And in my experience, you ought not to sign a lease that's longer than 3 years or 5 years in length. That's plenty of time to give the oil company the opportunity to consider whether or not they're going to drill on your property or not. To give them a longer period of time ties up your property longer than it really needs to. So I tell people 3 to 5 years is a maximum length of a lease that you ought to give to the oil company.
Once the time frame of the oil or gas lease has been considered, it's time to start thinking about payments.
The second thing is the oil company will generally provide what's called a bonus payment or an upfront payment that they will pay to you to lease your property. This has nothing to do with whether the well is successful or not, or whether it even gets drilled or not. It is just the right that, or the money that you get for them having the lease. And typically they will pay for a 3-year lease or a 5-year lease, whatever that amount of money is, up front. Now in my 30 plus years of experience in oil and gas leasing, I've seen bonus payments range from $5 to over $1,000. And it really depends on how much interest there is in your property, what the price of gas is, what the price of oil is. I generally indicate to clients that whatever the offer that the oil company makes initially is generally going to be a lower offer, and there ought to be extensive negotiations on that.
That upfront bonus payment is important, but the ongoing royalty payments could be even more significant and should be carefully negotiated.
The third thing that I think is critically important, and that is the royalty. In other words, if they drill on your property and if they get a successful gas or oil well, what part of the production are you going to get paid? The standard oil and gas lease, sort of the pre-printed standard form that is used by oil companies, usually says an eighth, 12.5%. In my opinion, most oil and gas companies will pay more than that. I've seen leases that have ranged from an eighth or 12.5% up to 25% or a quarter. Very, very rare is there do you get a quarter. Very rare is it that you get 20%. What I have seen be much more standard is instead of the eighth or 12.5% is maybe 15% or a sixth or a 3/16, which is 18.75%. My point is that if the royalty that's being offered is an eighth, you generally can do better than that, and you ought to have discussions.
As you can see, the legal aspects of oil and gas leasing can be complicated. That's exactly why expert legal advice can be a major advantage for people who own mineral rights.
There are many, many more things that you should be considering when you're negotiating the lease. But I think those three things I just talked about are the important things to sort of begin the discussion.
With My News 26, I'm Abigail Blackrick.